Hello and welcome to the final session of the NEC Users Group online conference for June 2021. Our topic today is the role of dispute boards in international engineering projects. And as you can see, this is going to be a panel discussion. My name is Jeremy Glover. I'm a partner of Fenwick Elliott and current president for Region 2 of the Dispute Resolution Board Foundation. Now, Region 2 covers everywhere outside of the USA and Australia. So I'm delighted to welcome you to our discussion today. As I've said, it's about the role of dispute boards on international engineering projects. Our panel members will be familiar to many of you, particularly those who are able to attend this morning's session and introduction to the role of dispute boards on engineering projects, which was given by Peter and Rob. However, for those of you who weren't present, I'll just quickly introduce them for you. Peter Higgins was chairman of the ICE panel, which prepared the NEC 3 contracts. He also led the team preparing the NEC form of contracts and guidance, and understandably is now chairman of the ICE NEC 4 contract board. Rob Horn is a partner at international law firm Osborne Clarke. He heads the construction and engineering disputes and risk practice, leading the infrastructure sector team. He's consistently ranked in all the legal directories as a leader in his field, with particular expertise in the NEC form of contract, and as a result has been involved in many of the biggest infrastructure projects let under the NEC form of contract here in the UK, including London 2012, the Olympics, HS1, HS2, Heathrow T5, Crossrail, and Thames Tideway. Our third panel member is Andy Griffiths. Andy has well over 40 years of experience, majority of which involving dams, tunnels, water projects. He's been intimately involved in some of Southern Africa's most prestigious projects, playing leading roles on the Thuna Dam in Botswana, Durban Harbour Tunnel, and the Lesotho Highlands Water Project. He's the immediate past president of the Dispute Resolution Board Foundation, the entire organisation and operation, and was the recipient of the DRBF 2019 Al Matthews Award for Dispute Board Excellence. So it's no surprise to find him a member of the ICE South Africa NEC list of adjudicators and the FIDIC President's list of approved dispute adjudicators, amongst others. But before we start, there's one or two matters of housekeeping, the usual type of thing with which we've all become familiar with over the past few months. Please turn off your microphones. You can submit questions throughout the presentation via the chat function. Put the full question in or state that you've got a question you'd like to ask verbally. I'll do my best to keep an eye on what's going on and try and introduce those questions as and when they emerge. And please keep your microphone on mute when speaking. So the way our session is going to work is quite simple, for me at least anyway. The questions are going to be on the screen, and then I'm going to ask our panelists for their views on them, and we can then discuss them as they come up. And just a very brief word on why we're having this session. Well, it's quite simply because dispute avoidance has always been a key part of the NEC agenda. And today it plays an increasingly important role across every project, and especially the large international projects. And that's where dispute boards can play an important role in assisting dispute avoidance. And as we all know, the NEC forms provide for the use. And so to begin with, the major issue, part one of this discussion, the main question there, why wouldn't I want a DAB in the UK just because the adjudication, the Housing Grants Act applies? Can you actually run the adjudication in parallel with each other? They all have different strengths. I suppose what the question's really asking is, why would I want to have a dispute board in the UK when I can rely on the housing grants quick form adjudication? So I think that's an issue that's it's a fundamental issue which goes to the establishment and the use of dispute boards in the UK. But maybe Rob, do you want to just start us off with a brief comment on the main point in issue here?
Yeah, sure. Thanks, Jeremy. I think for those that heard the morning session, you'll have heard me say the premise of W3 under the NEC 4, which brings in dispute boards, is that they're only operational where the Housing Grants Act doesn't apply, and that's the starting point. I guess what we're looking at here, and I think really sort of encapsulated within this question, is the idea of different strengths. So what a dispute board is really good at is getting ahead of problems, identifying issues as they arise on a project, bringing lots of expertise to a project team and looking for innovative, unusual solutions, ways to help the project team deal with what they're seeing on site. And adjudication, at least for me, perhaps this is a deviation from the idea of adjudication where it started all those years ago. But the idea of adjudication is that you just get a decision, a black and white, contractually based, legally based decision of the rights and wrongs, obligations of the parties under the contract. And it's that black and white type decision that you then enforce. But a black and white decision isn't always what the parties really need. Sometimes they do need a bit more innovation. They need a guiding hand more than a sharp stick telling them what the only possible answer is. So for me, I think they can run in parallel very well. You just need to think about what the objective is. What are you trying to achieve by having a dispute board and an adjudication body, in addition, remember, to the tribunal, which is the ultimate decision-making process for any dispute arising under the contract.
Okay, no, that's very helpful. So I mean, sort of the adjudicator there to resolve disputes. So dispute board, big role, avoidance, and we leads into the sort of the first point. What can a DAB do if they become aware of any disagreement between the parties? Andy, I mean, is that type of thing that you experience when you as a dispute board member?
Yes, Jeremy, I think it's a very important question. I think the function of a dispute board, when appointed, clearly the parties have gone for that option in NEC because they want to avoid disputes. A dispute board needs to be proactive. But that said, it's not there to do the job of the project manager or to tell the parties what they must do. Through its questioning, during a site visit and a site meeting, the DAB will go through the early warning register. It will go through the compensation event register, the program in progress, and try and encourage communication between the parties. If it then becomes aware through its questioning that there is a disagreement, then it would encourage the parties to ask the DAB to resolve it. The DAB, I would not recommend the DAB to jump in and say, oh, you guys have got a disagreement, let me give you the answer. But to try and sort of like take the horse to water, as it were, to ask the DAB's advice on that. So through careful questioning and encouraging open and free discussion between the parties.
Okay, thank you. Peter, is there anything that you'd want to add to that?
No, I think that's perfectly right. The DAB should be looking to identify things that really need to be resolved. I would suggest that the first thing the board would do is to refer to the parties and say, look, is this a problem you've got? Are you able to sort this problem out, or do you need to get me involved? Do you need to sort that, because that doesn't look as though it's working very well. And I think this actually runs into the second point there. What is a potential dispute? It's not defined. So when is a dispute? A potential dispute, you could argue, is one that's referred to under clause W3. But I think of it very simply as a potential dispute is something that the parties can't agree with, and unless they accept recommendation of the dispute board, it'll go to the tribunal. So it's a dispute in making, and what Andy's just referred to is the earliest stages of that dispute in making, and jumping in and trying to get the parties to think about it rather than let it wallow a little bit is a good move.
Okay, thank you. And I suppose Rob, when you sort of see sentences like potential dispute as something that's not defined or described, for some lawyers, their sort of ears sort of perk up, and they think there's sort of there's room for manoeuvre, shall we say here? I mean, do you think there's an issue here with with the fact that this isn't defined? Is it something that sort of should be fairly obvious to the parties?
So a couple of things that I'd pick up on here. Firstly, and I can say this because I think I've looked at this question in the past. This is a question that's fairly typical of lawyers. Lawyers ask this sort of question. Oh, you've used this term, but it's not defined. Well, how do I know what it means? Well, I think as Peter's just explained, it means what it means. A potential dispute is a potential dispute, something that we think is going to happen, but hasn't happened yet. This is not rocket science where we need to have a special definition for a pretty basic set of words. It's, look at it, think about it, apply it logically, don't get caught up in the detail. Having said that, of course, people pay lawyers an awful lot of money to find problems, pick away at holes, identify where there might be a loose thread and give it a tug and see what happens. Every contract has the odd loose thread or two. And even if you think it hasn't, give a lawyer long enough and they'll find one, because there's always a word that you can have a pull out and see what happens. And I think that's really what this question is aiming at. It's in trying to find a problem that I think in a practical sense doesn't really exist. If I can, Jeremy, I just wanted to pick up on something else that Andy said actually a minute or two ago, which I think is really important. And it's how the dispute board deals with the interaction of quite a number of different parties. So the dispute board's there to help the parties to the contract. The parties to the contract obviously are the client and the contractor. But managing that sort of personal relationship with the project manager and the supervisor, making sure they don't feel offended at what's being done or said by the dispute board is really, really important, because if the project manager or supervisor feel like they are being usurped or cut out of their role in the project, the ability for the dispute board to do their job is going to be significantly impacted.
Yeah, I mean, please go on.
No, sorry, I couldn't agree more. One of the challenges in practice for a dispute board is to arrive on site and instill that confidence, as opposed to having the parties saying, why do we need this bunch of old so-and-sos coming to tell us how to do our jobs? You're not there to tell them how to do the jobs. You're there to impart and help to keep them out of trouble. And hopefully, in the end, avoid paying you lawyers enormous fees to eventually resolve the problem.
I guess that's one of the other big differences between a dispute board and an adjudicator, because a dispute board doesn't really have that authority given to it in the contract. They have to generate their own authority by their interaction, the way they present themselves to the parties, rather than having a bunch of contractual terms that say the parties must do what the adjudicator says. It's quite a different dynamic.
And if I would add, the other place where a dispute board can play an important role as well is if you have got a very large, complex compensation event, claim, whatever you want to call it, which has a number of sub-issues within it, there may be one, or even say delay analysis type approach, there may be one stumbling block that is causing perhaps a fork in the road and making the parties go in different directions. The dispute board can then be called in to give a recommendation quickly on that issue, so the parties can decide, yes, we go down this road rather than going down the other one, and see where it takes us to the end of that larger overall claim, and see whether that comes to an effective solution.
Yeah, I mean, that makes sense to me. And I did note, Andy, you'll use the phrase whatever you choose to call it. And obviously the lawyer in me puts a small red flag at that, and sort of the needing to define terms. And we've talked about potential disputes, we've talked about claims, and obviously there's also under the NEC form and other contracts or references to early warning. Peter, what is the difference between all these terms? I mean, is there a difference?
Well, let's just look through them. Potential dispute. I mean, just going back to what I said earlier, a potential dispute is defined in the contract, I think, through the remedy. A dispute under the contract is a matter that wants to be referred to the tribunal, which has not been referred previously to the board. Sorry, has to be referred to the board as a potential dispute. So a potential dispute is something that is going to be referred, is something that needs to be resolved. Now, a claim, frankly, under the NEC, we don't have such things as claims. We've got rid of them completely. One of the big successes of NEC, we don't have claims. We have these things called compensation events and notice and whatever. So I don't think we need to worry about that. A potential dispute is something where a decision's been made about something, and I think I don't agree with it, and I'm not very happy with it, and I think I need to sort something out. Otherwise, it will become a dispute between us. So that's where I think that fits in. Early warning is an entirely different thing. Under the NEC, early warning is solely there to work out, we have this particular problem coming up, this risk coming up. How do we deal with it practically under the contract? What actions do we take? Who takes the actions, and how do we get over it to minimize the risk or avoid it? Whether there's some consequences in terms of time or money will be dealt with separately. It doesn't come out of the early warning meeting. So I think that's a very, very different animal to a potential dispute. Theoretically, there's no dispute under an early warning. You simply sort out what's to be done and who's going to be doing it. The dispute could arise later because somebody says, I'm not going to pay you for doing it, but that doesn't come out of the early warning. That's something that will come along later.
Okay. Well, with that in mind, is the early warning meeting something that the DAB should actually be involved in? I mean, should we be inviting the DAB to attend these meetings?
I'm not sure what the DAB is really interested in, whether there's a problem arising and likely to arise. The early warning is looking to see what needs to be done to deal with a particular risk. Now, it could be that there's a major risk coming up which has got significant effect on the contract, and it could be that the early warning, that the DAB could be attending that. But in general, I think probably they wouldn't, and there's two reasons for that. Number one is that there's not a lot of issue to be resolved, or that the board would want to get involved in immediately with the early warning. But secondly, I think there's going to be lots of early warning meetings happening when the board isn't there. So apart from attending the odd one just to see how the parties get on together, I'm not sure there's an awful lot going to come out of it. But it could be useful if you're going to a site visit and there's an early warning meeting scheduled to be held during the visit. It could be useful to go there just to get a feeling of the chemistry between the parties, how they're working together. But I don't think there's anything that comes out of it in terms of resolving disputes necessarily.
Okay. No, I mean, I understand that, but I think one of the interesting things you've said there is the reference to chemistry and the importance of the dispute board understanding the sort of chemistry of the parties. I think that's something that's already been touched on by Andy as well, and Rob.
Jeremy, sorry, there was something looking at that question on should the DABs be involved in early warning on our risk reduction meetings. I absolutely agree with everything Peter said. But it's interesting if you turn the question around, look at it on its head, and say should we bunch up our early warning meetings to make sure that the DAB is involved? And I think that really makes the answer very obvious and very stark. Is absolutely not. The whole point of the early warning is it's early. If you start delaying that in order to bring in your dispute board, you've kind of defeated the object of one of the best processes in the NEC. It might be that you want to review or have an additional risk reduction meeting while the DAB is on site, but you can't delay the primary process in order to involve the DB. It doesn't work that way around.
Okay, Andy, is that your experience too?
Yes, I would say it's the same way as in dispute board practice. I'm not that keen on attending the monthly site progress meetings, because quite a lot of the time there are issues discussed. The parties need to have opportunity to discuss amongst themselves. There are issues which perhaps aren't of that much relevance to the dispute board. What I do in practice, though, is I do have a session where, say in an NEC contract, how I would adapt it, is for the parties to take me through their early warning register and to confirm to me that they are managing the process properly. Because if they're not, then, as Peter said, then we could end up in trouble on the contract. That they are thinking ahead of what may happen, what could go wrong, and they're putting in place or thinking about it so they can avoid those issues. Because obviously, things that go wrong have a way of ending up in dispute. So I would probably have it on my DAB meeting agenda.
Okay, I mean that seems a sort of very sensible way of dealing with the issue, and sort of takes on board all the points that Peter and Rob have been making. The final bullet point on this particular slide is more specific, a specific issue, reference there being a very short period for the parties to agree a solution to a potential dispute. And then there's no time period for a DAB to issue its recommendation. How would you deal with that? I mean, Andy, so you're talking about your practical experience, the way you resolve these things. Is that something that's that you've had to deal with?
Yes, in a way, is that when you're asked to give a recommendation or opinion, say, I'll put that, both parties ask you to give an opinion. During this course of a site meeting, you would have a debate and a discussion where each party is discussing why it believes its view is correct. Obviously, the dispute board has been forewarned about it. You ask questions in that, and it may come out of that process that the parties themselves, maybe with a bit of prodding from the DAB, can see a solution. I don't think the NEC intention is they have to have a signed and sealed delivered agreement before the DAB leaves site. But if they said to the DAB, look, stop, don't spend any more time on it. We think we can resolve it. Give us a week. If not, we'll come back to you. I think that's probably the intention of that clause. And as to the recommendations, that again, it depends a lot on the parties and the nature of the disagreement or the potential dispute. In my practice, I find sometimes it can be such that if you have a site visit that involves an overnight stay, you can think about it in the evening. You can give them a verbal answer or recommendation in the morning to be followed up within a few days with a written recommendation, so they can get on with the project and the real purpose of building the project. If it's a bit more difficult, needs more research, perhaps take a few days, maybe even if it's a very difficult one, 2 to 3 weeks, all right, to be able to write up your recommendation on it with full reasoning. So you try and balance the urgency within which they need an answer, because of the impact it may have on the project, and the extent and scope of the potential dispute.
I guess this is another one of those sort of lawyery type questions, isn't it? Where lawyers like to have everything absolutely buttoned down with a particular hour in a particular day when you're going to have the response, balanced against the sort of more engineering or construction professional practicality of, do you know what, there's an awful lot of different sorts of things I could be involved in. What one might take 5 minutes to get my head around, one might take 5 months, because I don't know what's going to come up, and trying to find a way of encapsulating that balance into words is hard.
I would certainly not recommend that a dispute board take more than 28 days. An adjudicator is given 28 days to give it, that a dispute adjudication board wouldn't, dispute avoidance board would not take that length of time. The purpose
Just say from experience,
is to get an answer quickly.
So from experience, there's a range of different things that will require different times. I mean, one example is something comes up during the site visit. You're visiting every few months or whatever it may be. Something comes up in the site visit, you deal with it, you have some kind of a session and you resolve it there and then effectively. And as Andy said, you either next day produce a written recommendation or a few days later. What happens if a thing is referred to you when you're not actually due to make a site visit? You then need to decide, do I hang back till I make a site visit? Can I deal with it without going to site? Do I need to set up a special meeting to deal with this because it's a big project, big issue? And all of these affect what's going to happen. But clearly the intention is that the recommendation should be dealt with without delay, but you recognise that there will be reasons why it won't necessarily happen immediately.
Exactly, okay. Yeah. I would endorse what you say, Peter. And nowadays, with we're getting a bit more practiced with Zoom and MS Teams. There's no impediment to having a discussion at any point between site visits.
No, well, that's very true. I mean, we've been talking about recommendations. Andy, what is a recommendation? What standing does the recommendation have once it's been given?
Well, actually, I'll answer the question a bit differently. I'll leave the standing part of it to the lawyers who have a lot of fun with it. What I would say is, in dispute board practice around the world, there are the dispute board decisions, which are akin to an adjudicator's decision. They're temporarily binding and can become final and binding. That is prevalent mostly in the developing world. The USA practice is for a dispute board to give recommendations. That was the original concept. It was a dispute recommendation review board to give recommendations, which are non-binding on the parties. I think Australia adopts the same. They give dispute avoidance recommendations. Each one has its merits, and I think also depends quite a lot on the parties and the approach they have. Obviously, a lot of my practice is in the developing world. Sometimes the danger is that a recommendation requires somebody, particularly if it's from a government organization, perhaps with multilateral bank financing, has then got to make a decision whether to accept it or not. So sometimes they prefer to have the DAB say, here's the decision, get on with it. If you don't like it, refer it. You have to refer it to the tribunal to undo it. So there are pros and cons, and I would, the advantage obviously with a recommendation is it brings down the, the finality of the decision, and therefore can lend itself a lot better to a more informal approach, open discussion. Probably sometimes with a binding decision, it starts in some cases to make it difficult to tell the difference between a dispute adjudication and an arbitration, where you have suddenly all the lawyers arrive on site as well, and it becomes very long, very difficult. So I think the recommendation aspect fits much better with the NEC intention of cooperative and working and collaboration and trying to come to a quick solution. And if you don't like it, then you can spend all your money by taking it to the tribunal.
Okay. Peter, was there anything you wanted to add to that?
I've muted my microphone there to keep quiet for a moment. It fits with the NEC philosophy, as Andy says, which is to help people to resolve problems by working together. And it really says to the parties, look, this is what we think you should do. Go away and do it, or find your own solution, which is different. Rather than saying, this is it, get on with it, I've told you what the answer is. It's just a philosophy of NEC of trying to get people to work together to cooperate and to solve their problems. So it's very much intentional to be a recommendation rather than mandatory. I think there's a separate question, of course, which is maybe what Rob can deal with, which is what happens if you've got a recommendation and somebody is not really too happy to comply with it. Contract says you refer it to the tribunal, but yeah, maybe you don't want to go to the tribunal. The idea then is you try and resolve it yourself.
Okay, Rob, do you want to take up Peter's invitation?
Yeah, I think that sort of blends through into the next couple of bullet points on the slide, doesn't
Yes,
it? And it's sort of slight difficulty, and I'm very firmly putting my lawyer hat on now to sort of look at, you know, how does this work when you give it to a lawyer and you say, look, we've got this recommendation thing, what happens next? And the contract's quite clear. Contract says if you don't like that recommendation, if you don't agree with it, then you issue a notice of dissatisfaction and off you go to the tribunal. As Peter's just explained, off you go to the tribunal and you get that matter resolved by the tribunal, whatever that might be. And if we were talking at the beginning of this session, if you happen to have adjudication running in parallel with your dispute board, you could trot off to adjudication rather than the tribunal. So you could do all of that. The difficult area occurs with, well, what happens if no notice of dissatisfaction is given? You've got a recommendation that now can't be challenged because no one gave the notice of dissatisfaction. So the recommendation that Peter's just described with all the right ethos of getting the parties to work together and be collaborative and, you know, mutual trust and cooperate, all of that great stuff sort of almost slides off the rails because someone didn't do the notice of dissatisfaction. So the presumption is, under the contract, great, that means no one is dissatisfied, and therefore we carry on. But what's the value of my recommendation? Has the recommendation in some way metamorphosed, sort of caterpillar to butterfly like, into a decision without the parties really knowing that was what was going to happen? So a little bit of a question around what happens if you don't put in a notice of dissatisfaction. But I think that there's another problem. Again, you know, lawyers are great at layering problems on problems. So as I say, keeping my lawyer hat on, I'm going to layer another problem on. What happens if you have a dispute board process, a recommendation is made which is favourable, let's say, to the contractor, says the client has to pay the contractor some money. The contractor obviously isn't going to challenge that recommendation because he's, you know, happy days, he's got some cash coming to him. The employer is not happy with that answer because he doesn't want to pay any cash, so he puts the employer puts his notice of dissatisfaction in, but does not commence the tribunal process. What then can the contractor do in those circumstances? Obviously, the contractor didn't give a notice of dissatisfaction. The recommendation doesn't become binding because a notice of dissatisfaction has been issued. The contractor presumably must commence the tribunal process themselves because a notice of dissatisfaction has been issued, even if it's not their notice of dissatisfaction. But it's not, from a lawyer's perspective, it's not entirely clear. It's not, you know, nice set of guide rails of this is exactly what you do in this scenario. I think taking off my lawyer hat for a moment and looking at it as a more sort of practical, pragmatic NEC practitioner, It's very easy to get wrapped up in the detail, but actually the practical solution is almost always there. If for me, if you've got a recommendation, then it's a recommendation, and it always has the status of recommendation. You can't suddenly change into something else just because some process hasn't quite been followed. So that's where I would like to get to with my sort of NEC practitioner hat. My lawyer hat says, no, that's not how it works. It says you can't go to tribunal if you haven't issued your notice, so you can't go to tribunal, and that recommendation has magically become final and binding. So I think it's a difficult area, and you would hope that actually through the dispute board doing their job, the parties entering into the whole spirit of the contractual mechanism as they had intended to when they set out on the NEC journey, you would never get there. But you know, the nature of what I do for my day job suggests that they do. And if you have enough projects, you know, statistics say some will hit this spot. And I don't think there's an easy answer to this.
I mean, is one issue the 4-week period to give the notice of dissatisfaction?
Well, that sounded like it was going to be a really interesting question.
I think
I'm sorry. My internet briefly went down. I was hoping to say that can the parties extend the 4-week notice of dissatisfaction period, or are they stuck with it? Because sometimes you might be able to achieve a resolution if you have longer to sort things out.
So I think
sorry, Rob, I jumped in after you.
So from a lawyer's perspective, it's really easy. If the parties both want to agree something, then they can agree it. It might need a certain degree of formality around it, but absolutely they can. I think the practical problem that I often see is once you've got to this stage where you've got a recommendation that's in favour of one party and at least perceived as being not in favour of the other party, trying to get agreement at that stage to change anything is exponentially harder than it was before.
Yeah, I would say that the contract allows the parties to change, or the project manager can contractually change a timescale as long as it hasn't already expired. But the point there is that if you're thinking about extending the timescale, it's got to be for a reason. You need some more time to do something. What are you going to do in this extra time, which is needed? Presumably, it's because you want extra time to talk about this recommendation to see if you can reach agreement on a compromise instead of going to the tribunal. And fine, if that's what the parties want to do, that's brilliant. But just simply to extend it to avoid the need to go to the tribunal, it doesn't make a lot of sense. If you want to go if you don't agree with it, you're not going to live with it, and you can't reach an accommodation over it, then go to the tribunal or just drop it and say, well, I'll live with the consequences.
I would just add, though, as a point, there are certain government organizations, and again, say if you're in an environment where you've got a multilateral bank as a financing agency, where a decision as to whether to dispute the recommendation may take some time to work through the bureaucracy. But that would be known up front, really, and you could actually deal with it in the Z clause by saying, well, you must decide within 3 months instead of 4 weeks or so.
Yeah, I think you're absolutely right. And any time you have that sort of,
yeah, if you have to go to the bank to get a no objection to it also. Yeah,
you're definitely going to be adding at least 4 weeks to that time period, whatever the time period is, to get a turnaround from a bank or other lender.
Yeah.
Okay, that's interesting. Also interesting, the involvement of the sort of the world of the multilateral banks and the world banks in these issues. Again, the final point on the slide is a more specific question. DAB's made a recommendation confirming contractors due payment under a compensation event. What happens if the employer simply ignores that recommendation? Is it just off to the lawyers, Rob?
So I think what I would be saying to a contractor in those circumstances is, if the client has completely ignored it, hasn't put in a notice of dissatisfaction, I would use that, go straight to the tribunal and look for a summary decision from the tribunal in favour of the contractor for payment, on the basis that there can't be a dispute anymore, because if there was, they would have issued a notice of dissatisfaction. So effectively, you're looking for, in UK court terms, you'd be looking for a summary judgment, or even potentially a default judgment, because it is an undefendable claim, and the equivalent under the appropriate arbitration rules. I think you're more likely to get a court interested in giving you that sort of relief. Arbitrators are a little bit more difficult, so a little bit more difficult in your typical international context, where you're more likely to have arbitration. Easier in a pure UK domestic sense, but not as easy as adjudication under UK domestic law.
Okay. And your Peter, is there anything that you might want to add to that?
No, I think it's a legal point rather than a practical one. So I'd leave it to the lawyers to tell me what the answer is.
Yeah, I would think in my jurisdiction in South Africa, I think we've had very concise judgments enforcing adjudicators' decisions on every which way form of contract, including NEC, and I think this will then be just added to the list quite summarily by our courts.
No. I can see that, but maybe not every jurisdiction. Some jurisdictions seem to keen to summarily enforce decisions of boards, recommendations of boards, even if they've become final and binding. Often ways round. But changing tack quite considerably, although lawyers do tend to get involved in disputes about conflicts and disclosure. Very important, I suppose, for DABs to be independent, to be seen to be independent, to be independent. And there's all sorts of little sort of trips and traps that dispute boards might sort of find themselves sort of with a little bit of difficulty in. And so we're talking about conflicts and disclosure. I mean, up front, remember, what type of things do you have to think up front in interest before you actually accept the appointment? I know that's not a question on the slide, but I think it's probably quite a good starting point for the discussion.
Right. If I could jump in, I think, and I'll make a plug for the DRBF manual. The DRBF publishes a manual called the Dispute Board Manual, which is freely downloadable from the DRBF website. Or I checked this morning, you can buy it from Amazon for the princely sum of about $1.15 in ebook format. And in there, it covers, the DRBF tries to cover practice throughout the globe, whether it be in North America, the developing world, Australia, and so forth. And we put in a number of canons of ethical conduct. And I think the essential point is you need to develop trust and credibility with the parties. And your behavior must be impeccable. And I think in disclosure is any prior relations with the parties, if in doubt, disclose it. I think you don't want to end up at a site visit and suddenly somebody else starts accusing the dispute board of being biased or being pro one party and so forth. But often in practice, it happens, you turn up on site and you find that you've worked with one of the guys on site 5-6 years ago. So therefore, I believe that the dispute board practitioner must be right up front and declare in that meeting to say, Joe over there, I've worked with him in the past, but that won't affect my impartiality in conducting my role.
Okay. Yeah, I mean, I think the idea of being completely upfront is always the right course of action. If someone's got an issue with that, then they should say so before things sort of get out of hand. But I suppose sort of some of the potential issues are sort of currently up on the slides. I suppose taking them and sort of trying to take them in sort of chronological order. What happens if you're on the same flight as one of the parties? Andy, I'll take Andy first because sort of with sort of practice, and then sort of come to Peter and Rob.
Well, I think that's one of the always the challenges, but it's sometimes unavoidable because it's the only flight to that country or to the site. I think you've always got to be at pains to avoid discussing the project. And then when you arrive on site, so say you're traveling to country X, the employer and the project manager are based on site. The employer is usually based in that country, and you arrive with the contractor's representative on the same flight. Is, to be clear, to say, apologies, this is the only way we can get here. We did not discuss the project. Let me assure you of that. It's important on the first visit, and hopefully as time develops, the parties get confidence that you aren't going to be making side deals or being told things that you shouldn't be told.
Okay, Rob, would that satisfy you as a lawyer if you had that explanation sort of from the dispute board?
Yeah, I think so. I think Andy's exactly right. It's making sure you're upfront, making sure you're clear about what has happened. I think, you know, a lot of the time you're as likely to see lawyers or other professionals acting on those flights into country, and those conversations are usually okay. Everyone knows the game. Everyone knows what is acceptable to talk about and what is unacceptable to talk about. The bigger problem tends to arise when you are talking to the contractors, people on who have worked on the site, because they don't understand the rules of engagement. And you have to remember, you're the professional in that circumstance. You're the I hesitate to say, you're the responsible adult in that conversation. You take responsibility for making sure it goes in the right way and that it's reported in the right way to the right people.
Okay, no, that seems sensible. Peter, have you any views about sort of the idea, sort of the first?
I've never had to face a problem on flights. I mean, the other issues I have dealt with, and I think the clue in the first place, in my mind, is that you try to get sorted out in advance the arrangements for the site visit, such that the number of potential issues are unexpected issues are identified and removed. So, when just dealing with the other ones, for example, I had arrangements when flying out. First thing was I was met at the airport by the contractor's driver and taken to the hotel, where the contractor was staying in the same hotel, which is kept apart. But then the next day you travel to the site, fly out to the site, and I'm met at the airport by the resident engineer and taken for accommodation to the camp that the contractor had constructed for the client, because that was where I was going to be staying. Now, all of this was reasonably okay because it had all been identified up front in advance. It could start to cause a problem if suddenly people find out that's what you're doing and they didn't know about it, and they might feel a bit funny, something a bit funny going on. So that seems to me that the clue thing, as Andy says, be upfront, disclose anything that's happening, but I'd go further and say, if you're making arrangements for travel and accommodation and whatever on the project when you're making a visit, try and get them all agreed and identified and accepted in advance as being sensible ones to do. And then, well, yeah, make sure you don't start talking about problems on site when you're being driven to from the airport or whatever.
Okay, I mean, it's a belt and braces approach that if we take the supervised transport from the site to the airport issue first, that the dispute board should be arranging that. I mean, sometimes obviously it's just not going to be possible if you're actually in a remote position.
I would add, look, a lot of countries I travel to, I wouldn't like to be driving in those countries. It's better to have a driver. Sometimes I've had experience where you have to check that the driver is in fact a driver and not a junior engineer who has the best command of English and tasked with trying to listen to whatever the dispute board is talking about in the back of the car. You have to be careful of that. Quite often, I think in developing countries, you want a driver either provided by the employer or by the contractor, or a rental car that comes with the driver. And similarly, I think with accommodation, with canteen facilities, it's just to be sure that the principle is each party should be able to hear exactly what the dispute board hears. So if you're at the hotel and it's just you and the employer, or it's you and in the canteen, you and the contractor, then you sit apart, you stay apart. If both parties are there at the appropriate level, then it's okay to all sit at a table together, but never be seen with just one side.
So if a dispute board happened to be there for, I don't know, say 3 evenings, and so evening 1 had dinner with the contractor and evening 2 had dinner with the employer's side, that wouldn't be a good way of proceeding, or is that? But that seems to me it's a fair way of proceeding. It's sort of sharing the dispute board's time.
Well, it's one way of then establishing with each party that you're not prepared to talk about the project. You're happy to talk about football, politics. Maybe politics is not a good one to talk about, but football or whatever at the table, but certainly not about the project. That can help establish your credentials. Personally, I prefer to say, thank you very much, I'll just sit over here on my own.
Okay.
I think it's a really difficult balance. I think so. My starting point, particularly under the NEC, where you're making recommendations, you're not making decisions. So you're helping the party. So I get, in those circumstances, I get a lot less excited over all of these points, because the board aren't making decisions, not going to impose anything on the parties, no matter what they say. So if one of the parties doesn't like the recommendation because the board's been off chatting with someone else, you just don't accept the recommendation. It doesn't go anywhere, but it does sort of undermine the value of the board in the first place, which leads to the bigger point, which I think Andy just touched on, which is this is all about credibility. And the board has to establish its credibility, and part of its credibility is that it holds a balance between the parties and isn't swayed by sitting on one table or a different table, or being accommodated by one party or the other party. All of that goes to the board's credibility. And if you can't establish your credibility and therefore your persuasiveness, you're not going to be able to do your job as a tribunal. So as a lawyer, I tend not to get particularly excited, because I'm never going to challenge anything particularly, because there isn't anything to challenge. It's a recommendation. But to make the board work effectively, you need to have thought about these things and the perception that goes along with it, I think is my view.
Okay, so when you're talking about perceptions, the final bullet on the slide talking about being taken to one side in the course of a site visit. How would you deal with that, Peter? Is that something that you've come across, or in sort of visits you've made?
Yeah, it happens quite a lot. You're on a site visit and the contractor calls you over and says, "Look, come and look at this. Come and look at this." The resident engineer is being quite unreasonable here. Immediately, you call the other side over to join you on that inspection. You don't let one of the parties talk to you separately. If the contractor wants to point something out to you, you bring the resident engineer, the client, or whoever is on the visit with you to come and look at it with you and listen to what's being said. Just listening to one party by themselves is really dangerous. That's the point I think both of us are just, Andy and what we've just been saying, that you need the credibility. If you're going to listen to one party alone, then you suddenly, the other party is going to be very suspicious of you, because what were they talking about? What did they discuss? What did they decide? How was that person influenced? So just avoid it. Just make sure that if that's happening, you bring the other party with you. And that has happened to me a number of occasions on visits. Contractor wants to say something, or perhaps the resident engineer wants to say, look at the mess the contractor's making here. You bring the other party with you, rather than just let one party talk to you.
But I mean, if one of the parties is able to talk to one of the three of you individually, as during the course of a site visit, perhaps, or whatever it might be, there's an opportunity there for the contractor or the employer to say, well, look, just actually, this is what's really going on. I can't say that sort of in front of the contractor, and sort of try and give you a fuller picture of what's going on, sort of try and help you understand the picture. It's not. I mean, sometimes parties are more sort of reluctant to be saying things in sort of in an open forum, but they might be more, you know, that they trust you because you've demonstrated, because you won't have dinner with them, or the approach, and they recognise that you are sort of very sort of down the line. The sort of they can see and they admire where you're coming from, but they want to tell you things, but then they're not things that they want to bring out into an open forum. You can't make your recommendation unless you properly understand the decision. I mean, isn't that sort of something you might have to deal with? I mean,
you can do that as a mediator, but I don't think you can do that as a dispute board member. You suddenly look. I mean, this concept, haven't we, that we've just developed, that says that this is my truth. You're getting one side of the argument, which may or may not be correct, but that's that person's perception of it, and it's not being challenged. I don't know how you can listen to that and take any value off it, if in fact it's just one party saying what they think. They think the other party is being quite unreasonable. They don't want you to tell them that because it might upset them. But does that mean that you accept they are being unreasonable, or what? I don't think there's any value to be gained by listening to one party, because it undermines the other party's confidence in you as soon as they know it's been happening. And I'm not sure you can use anything that party gives you in any valuable way unless it's open disclosure.
Can I be a little bit more controversial? And if nothing else, it's sort of to challenge that idea, which I think is absolutely, that's got to be the right starting point, is to maintain that even-handedness. I think there are some dispute board rules that make specific allowance for talking to parties on their own. Rightly or wrongly, we might all agree or disagree, but there are some rules that specifically provide for it. And I think one of the things we have to be a little bit mindful of, I was going to say, as we all sit here in the UK, virtually sit here in a sort of UK-driven environment, the way we do business in a Western European sense is not the way everyone does business all around the world. So a little bit of cultural sensitivity, where people approach problems in a very different way and are prepared to open up about what the real issues are, I think just needs a little bit of thought from the dispute board. Otherwise, they're going to find potentially what they get always is very bland, positive answers to every question they ask, and then all of a sudden the whole thing blows up and it's a complete disaster that you didn't see coming, because no one would give you the real truth, because they didn't feel able to give you that information in the sorts of meetings that you were making allowance for. That's a really difficult area and takes a lot of expertise to find what the right balance is, but I think we can't rule it out completely that you would never do that.
I think, Mike, I can understand it if you were saying parties were happy for you to do that, but for one party not to know it's going on, I think it's quite dangerous. But maybe there are rules, ways of dealing with it. I've not been working under any rules which would sanction that kind of work, I don't think, and I don't think NEC would expect it under the W3 approach.
I think, Rob, you raise a really important point about the cultural differences, particularly in an international context. And I think the dispute board, DAB, members need to be very aware of it. And particularly where cultural issues or language difficulties maybe there, it's easy for us English speakers, if the contractor is English speaking or even European and he's very fluent in English, easier to get along. The employer might not be able to follow the conversation quite as well, or the contractor, if he's a Chinese contractor or Turkish or from a different country. So the DAB has to be very sensitive to that. Make sure that you allow sufficient time for each person to be able to express himself and to make sure that the other side actually understands what's being said. And you have to create an environment where all the parties feel comfortable to talk openly. You might have a view. I tend to say my site visit and DAB meetings, although there's a report, are entirely without prejudice. If a potential dispute is referred to me, that will be decided on the documents in a special section of the hearing or of the meeting and discussion and the documents. But what is explained to me on site won't be sort of held against you at some other stage if I have to issue a recommendation. All in an attempt to foster this environment where everybody feels comfortable in speaking freely and openly about their problems.
I had another point, a sort of practical point on that site visit that I really appreciate, Peter, and your view on, because it's something that I've seen quite often. And you can go to a site visit and you'll have that the people you are literally talking to as you're going around the site will be the contractor's project manager, the resident engineer, almost certainly the two of those will be leading the conversation. You'll have a representative more senior from the contractor who probably has come up through the ranks of the business, so knows contracting, knows what he's looking at, and someone from the employer who 50-50 has no relevant construction knowledge at all. And just sort of going back to that inclusiveness point, it's very easy, isn't it, on a site visit just to end up talking about construction with those who understand construction. But in doing that, you can very easily isolate that senior representative of the employer. You've got to find a way of making sure they come back into, or at least understand the conversation, the things that you're talking about. It's a difficult dynamic, isn't it?
Yeah, I think to a degree, one relies on the resident engineer keeping the employer briefed and understanding as to what the issues are, and they probably knew about the issue before you did anyway. But yeah, it is an issue where you've got a mixture of different cultures. For example, a Korean contractor, an African national client, an American consultant, all working on the same project, and they've got different ways of doing things and talking about things. So you do have to play that a little bit. But as I say, the key thing is to be able to listen to what people are saying, understand it, and make sure that the other side have got the opportunity of dealing with whatever points are being brought up. How we do that and how we make sure that people follow it is a question which you say is quite a tricky one to get the balance right, but it's something we need to do.
And if I'd add, taking Peter, both points there, which I agree with 100%. Also, the DAB and the parties need to be flexible. Quite often, a senior representative of the employer will not be willing to spend 2 days traveling out to a site for a site inspection, a DAB meeting, and so forth. Perhaps he can't afford that time or is not prepared to devote that time. So sometimes you may have to consider to ensure you have an appropriate decision maker from the employer there is perhaps you have a site visit and hold the DAB meeting at a different location, at a more convenient location, where the right people at the right level can attend the meeting. People who can make decisions can attend the meeting. And you must
that
horses for horses. Sorry, you must choose the appropriate.
Yeah, I was just going to say that is that type of thing easier in current circumstances where you may be having sort of virtual site visits?
I'd say it's easier to get the people around the screen than it is perhaps at some point 3 hours away from the nearest city. That the problem is the cultural and language difficulties become much more difficult to manage through this virtual forum.
So
I've never done one, so sorry, I just going to say I've never tried doing one, so I couldn't really comment, but I don't think I'd relish having a DAB meeting by Zoom. It could be done, I guess, if you needed to, but it's probably not the best way of doing it, I suspect.
I've had very many of them. And it's also amazing the correlation between the Wi-Fi going out when the difficult questions are being asked.
Yeah, it's funny. Yeah, I've seen that too. I mean, one thing I've also seen from virtual dispute board meetings is that more people attend. I suppose that's because it's far easier for people to attend if they're not going to a remote site, and that can create its own difficulties for the dispute board because there's only going to be a small number of people that they actually want to to hear from, and you suddenly find that there's many more participants, which can make the job slightly more difficult for a dispute board.
Yeah.
Okay, so we then got some final questions, sort of rooted in part in the contract, and sort of looking at sort of the first one, the 3.31 prevents reference to the tribunal if the DAB process has not been completed. Is that going to interfere with interim remedies like injunctions to prevent a contractor covering up the work? I suppose, Rob, that's with reference to injunctions, that might be a question for you first, at least.
Yeah, I mean, I think so. We've talked about what happens in this DAB process and tribunal and how you can manage that in a slightly different context. I think the answer here is actually relatively simple and straightforward, at least in a UK context and primarily a UK court type scenario. Unless you've got something really specific in your contract, which W3.3 is not. This is not going to prevent any interim actions and remedies being made available from the court, whether that's positive injunctions, negative injunctions, any other sort of support that the court might want to give or might be persuaded to give, you're going to have available to you, in the same way that even where you've got an arbitration, you can still get interim relief support from the court in certain circumstances. I can't see it's going to be any different. As I say, in the UK, I think the thing that's you have to be quite careful of is that's not necessarily going to be the case in other legal systems. So you have to look quite carefully at your local law process and see what impact that might have on any interim reliefs you might otherwise have available. And the answer, unfortunately, is it might interfere in a wider international context, but not being a lawyer qualified in every legal system in the world, unfortunately, I couldn't really say, other than it's something you need to look at. Otherwise, you could lose out.
Okay. Thank you. Another question that's sort of been I've seen come in. What happens in the case of death or inability to act by a board member? Andy, is that something that you might be able to comment on?
Well, yes, it is provided for in the contract, death or inability to act. I think, as Rob pointed out this morning, there isn't a provision, or it might be Peter, excuse me, there isn't an express provision in the contract that permits the parties or a party to unilaterally get rid of a dispute board member. I would presume if both parties agree, they can fire a dispute board member. The contract does provide that if one of the members dies, for instance, they can agree a replacement and appoint a replacement for that. And if they can't agree, you get the nominating body to appoint somebody. Interestingly, I've actually recently had a case where, unfortunately, one of our 3 DAB members did pass away. The project is nearing completion. The parties actually agreed that they would prefer just to carry on with a 2-person DAB. They felt it was far too late to bring a new person on and try and get him or her up to speed with the project at this stage.
Okay, I suppose a sign that the parties had confidence in what the DAB had been doing to date.
Yeah.
Looking again at the slides and the sort of question talking about DB inspecting the progress of the works. What's that about? What does inspect mean? Does inspection have any sort of particular or special meaning? So there are concerns under some contracts about what the word inspection means and what sort of duties and potential liabilities that might impose on the party carrying out the inspection. What does that actually mean in the context of here when we're talking about dispute boards? Again, sorry, Andy, I think that might be one that you would want to comment on first.
All right. Well, as an engineer, the fact that they used the word inspect didn't actually jump out and put the fear of God into me about it. I think obviously, and it was said this morning, visiting the project, inspecting what's going on or viewing what is happening gives you a far greater understanding of the problem of the project and the problems that have arisen if you have to be called on to give a recommendation or to help the parties avoid the disputes. But also, when you go on a site visit, you also see the interaction between the parties. How are they getting on? Sometimes you might find that communication is not what it should be. They're sitting in their site offices, just sending emails to each other rather than maybe walking across the yard to have a discussion. And things are not how they should be. Typically on a site visit, my process is to view the works, to see if there are problems, what is happening. You, as experienced construction people, you can get a feel for the order and the housekeeping and whether things are being done well or not. You also review progress, you review the program. Highly important, and the progress the contractor is relative to the program. Are they maintaining the program, updating it regularly? All those good things, construction issues and challenges, the risk register, all those things, the NEC is there and promotes best project management practice. And part of the dispute DAB, I would believe, is to check that the parties are applying best project management practices. Because every time I've sat as an adjudicator, not every time, the vast majority of NEC adjudications I've done are the result of one of the parties not following best project management practices. So that's one of the important dispute avoidance roles that the DAB can go through. And I've already mentioned then having discussion about all the compensation events, potential disputes, if they're coming up, having a discussion to make sure that things are being dealt with as and when they arise, and not being sort of kicked down the road to say, well, we'll deal with that later.
Okay, thank you. Thank you. Peter.
I'm not sure whether my system froze there. Was this one of these difficult questions?
I think it's an open question for you, Peter.
Yeah, what do you mean by I guess you want me to add a little bit about the inspections. I mean, what the contract says, he visits the site to inspect the works and to establish whether there's any potential disputes, consider whether there's potential disputes. And for that, I think you read the word inspect in its context as to what the dispute board is doing. In the same way as if a supervisor is doing inspection, they're doing that in the context of satisfying themselves that the works have been built correctly. The dispute board is carrying out its inspection in the context of seeing whether, I think as Andy said, the parties are following best practice, they're doing the things that they ought to be doing. The progress of the works is quite a wide statement. Are the works being progressed in the correct way? Is it on programme? Are they actually properly dealing with compensation event notifications? Are they having sensible early warning meetings and such like? So it's quite a wide context. What is it that project managers are looking at doing? They're looking to identify potential disputes and deal with them, so they don't become disputes. And so the inspection is carried out in order to become sufficiently aware of what's happening on the project to be able to discharge that function.
Okay, thank you. And apologies for dropping out again. And Peter, what about the role of subcontractors, project manager, supervisor? There's a lot of focus on the role of the client contractor, I suppose, because they're the two parties to the contract with the DAB. What about the other relevant parties? Should DABs be engaging with them, interacting with them, or should they solely be focused on the client and the contractor?
I think if take the case of a subcontractor, for example. Let's assume that there is an issue arising, which is a key issue as the subcontractor is involved in. The contractor is acting as basically as middleman, really. The subcontractor is doing something that the project manager is not happy with, or the subcontractor isn't content with the valuation that the project manager is making of a compensation event, whatever it may be. Then clearly you need to understand what the subcontractor issue is rather than just simply the contractor. How that's done, I think, is entirely up to the board as to what they need to do. You might well be asking to the contractor, well, we're going to hold a meeting to discuss this thing. I presume you're bringing the subcontractor along to explain it, will you? It's a matter of what is the issue you need to deal with, who needs to be around, and what is the best way of the dispute board being briefed on what the real issue is by the people who know what it is. And that could be the subcontractor or supplier. Clearly the project manager is almost certainly going to be attending the meeting anyway, and you may want to call the supervisor in as well. So if there's a need for people to get involved, then surely they will be involved. But basically you need to recognise that the issue is potentially one between the client and the contractor. So how are you going to deal with that one? You need to be just pushing the parties to make sure that the right people are there to give you the first-hand advice as to what's going on.
Okay, and Rob, would you agree with that?
Yeah, I think so. So I'd look at it from two perspectives. I think if you go back to the beginning of the project, you can probably wrap all that up in your individual contracts that you're entering into with all of these people, and make sure that the DAB is being wrapped into their professional services contract appointments, the subcontracts, supply agreements, whatever it is. So you come back to a sort of single source of truth or single point of contact for all of that, if you're at that stage. Looking at it sort of from the mid-project stage, to some extent, it can be really useful, I would say, if someone wants to block any of these people from being involved or open to question or discussion with the DAB, you know there's a bigger problem than you thought there was. If the client says, no, you can't speak to the project manager, or the contractor says, no, you can't talk to my suppliers, you know there's a problem there, and you need to find a strategy to uncover exactly what that problem is, but at least it's been flagged to you. You can't force the issue, you can just deal with what's in front of you.
Okay, thank you. Our final point.
I would struggle
please.
to see how you can have an effective DAB without the project manager. I think he's a key participant, and the supervisor not far behind him, particularly if there are potential disputes arising out of quality, health and safety, social, environmental issues, and all that. The supervisor is also a key individual.
Okay, but would you ever seek to prevent lawyers from attending meetings with you? Are they key individuals too?
I've always been too scared to try. I've never had lawyers attend a regular DAB meeting. No, I tell a lie. I have. Certainly, they've attended the discussions on disputes and the claims. And I know it's a big debate in the industry whether lawyers should be allowed to darken the door of the process. I think quite often I find that lawyers can help direct their, whether it be the employer and project manager or the contractor, direct their principles in the right sort of approach. Speaking as an engineer, it takes a long time to get into this route because we're not trained on how to present an argument, even how to present a claim and a compensation event, whereas lawyers are trained in that. So as a practitioner, I can tell when a contractor or an employer's position paper, for instance, has had the hand of a lawyer behind it. So they do have a role, but I think, and the good construction lawyers, and I'm sure Jeremy and Rob, you fall within that category, realize that the DAB process, as with adjudication, is there to try and resolve issues quickly at low expense. So it's a bit of sacrifice accuracy and detail and precision in order to get an answer quickly.
Yeah, I mean, I think that's right, Andy, and it's very useful, interesting comment from Robert Gerard in the chat, talking about sort of the role of the DAB. You're not necessarily weighing up evidence; you're drawing on your experience to help parties resolve disputes. And in a sense, it almost means you stop acting in a decision-making capacity because that's not quite what your role is in the NEC form. We're almost out of time, so I wonder, Rob, if you could just answer, or maybe we are out of time. I'm wondering, Rob, if you could just quickly answer the final bullet points and make sure we've covered all the points that we were hoping to today about what whether there's any grounds for DAB member ever to be called as a witness.
Sure, and I think this is another one of those scenarios where this is a lawyer's dream of trying to pull on a thread and see if you can make everything fall apart. I think the reality is the protection at W335 is intended to stop dispute board members being pulled into tribunal to explain how they've given a recommendation that they've given, or what the thought process was, or anything like that. I think, subject to Andy's point earlier about clearly making meetings without prejudice, I think where a dispute board member physically obtains evidence, so goes to site and sees something specific, there's no reason why the member couldn't be called upon to give evidence as to what he personally experienced. No interpretation, nothing else. I'm thinking of a scenario where, not that that tribunal member was the only person to see it, but maybe he's the only person who is accessible or traceable, who saw that particular set of circumstances, because dispute board members are relatively easier to get hold of than project team members who maybe disappear off around the globe after the project has finished. So I don't think there's any reason why you couldn't. Personally, if I was a dispute board member in those circumstances, I'd be happy to give that evidence of exactly what I, as a matter of fact, saw. Obviously not the sort of broader process of what you've done. I think it's highly unlikely that you'd get an injunction to stop that type of factual evidence being given of what was observed on site. But equally, you absolutely would get an injunction to stop anyone digging into that process information or interpretive information that the dispute board might have shared between themselves. So I think it's a difficult area, but I think it divides nicely into two different pieces.
Brilliant. That was very clear. So thank you very much, Peter, Rob, and Andy, for your contribution today, and thank you very much for everyone for participating, being part of the webinar. And I think, good context. I think dispute boards are here to stay, and they have a valuable role under the NEC form of contract. So thank you very much for your attention and participation. Now it's time for the closing remarks to the conference as a whole.
Great. Thanks very much for that, Jeremy. Wow, what a conversation. Only came into the last 10 minutes in that, but brilliant, really informative. So thank you again for that. So I'm here to sort of provide some closing remarks across the past 3 days following the conference, the different mornings and afternoon sessions that we've had. I really do hope that you've all found this really useful and informative. I know I have. I think it's been a great session, really interactive, really warm from the users, lots of Q&A, which has been really helpful to keep the themes really interesting and interactive. Some of the key themes for me that have come out across the different presentations and workshops have been around collaborating to succeed, right across each of the conversations. Always communicating effectively as well, of course, being consistent in the approach to achieving net zero, as an example, where we started on Monday morning, and importantly, how to measure that as well. That will help achieve success in those areas. Start small, so nothing is insurmountable in any of this, but don't forget that a small change can have a big impact. So be bold, be brave. And of course, the versatility, the NEC forms, now effective in different sectors like oil and gas and pharmaceutical, as we've seen from the different presentations there. So increased usage across the sectors within a vast industry, which is really pleasing to see. I just want to congratulate as well all of those nominees and winners in the NEC Awards. Well done, great achievement. And of course, thank you to all of the submissions that came through. We do really appreciate those and keep them coming for next time as well. Thank you to all the supporters in helping spread the message of this event and gathering all of you here across the 3 days. And of course, to all the speakers as well and those workshop facilitators. I think it's worked effectively well in a kind of a remote world that we're now in. And just sort of to finalise then, I guess there's a few key messages from NEC that I just wanted to remind and reiterate ourselves with. Firstly, to accommodate this new online world that we find ourselves in, we've made the membership offering global. So we've got 4 levels of corporate membership, which anybody from any organisation in the world can join, as well as new grades for individuals and affiliate members. And the aim of this is to support the growing interest in NEC contracts worldwide, and obviously to try and avoid differentiation between users in different regions. We'll also be launching an app which will be exclusive to user group members. So this is going to serve as an information hub for NEC content, allowing you to interact with each other through its messaging service and stay up to date with any news via push notifications. The app's going to be launched at the beginning of July, and again, this builds upon the collaboration theme and the consistency theme that I've talked about, that I think is a key message from the conference. And also, as a thank you for attending, we've offered delegates a complimentary copy of the new FM contract, so hopefully you've been able to download that. It was on the resources section within the platform, and it's time stamped, so it will expire on the 30th of September. We've also got some training portfolios available. So NEC anyway offer an impressive training portfolio on the website, so please remember to go and have a look at that. But also the ICE training have some specific training courses related to carbon management in infrastructure. So make sure you go and check those out. And to further support the training needs of yourselves as users, ICE Publishing are offering a 10% discount on the NEC publications to all conference delegates. So you can take advantage of this by entering the code NEC Books 10 at the website checkout. So please make sure you do that. And once again, thank you for your attendance. This is the second year we've run this online, different to face-to-face, of course. Who knows where we'll be next year. Next time the conference round, but hopefully you've found it really useful. I know it's been a success, and a last thank you from me to the organisers of the event. You know, the massive amount of effort that goes into this, huge amount of effort, and often it falls on 1 or 2 people's shoulders to make it a success. So thank you to that particular team. I know there was some last minute changes at the 11th hour as well as we approached Friday evening. So well done. It's been a success on my part. Again, hope everybody has enjoyed it. Enjoy the rest of your day and your week. Take care now. Bye-bye.